This hearing of the on the Judiciary Subcommittee on Commercial and Administrative Law will come to order. I will recognize myself for a short statement. It has been nearly 5 months since an unprecedented number of U.S. attorneys were fired midterm without cause and without explanation. 5 months have passed since December 7, 2006, and we are still trying to understand why these talented and experienced U.S. attorneys were forced to resign. As the facts unfold, we are left with more questions than answers. What we have learned so far is troubling and warrants further inquiry. We have learned that the Bush administration exploited the change in interim appointment limits of U.S. attorneys by purging high-performing U.S. attorneys. When the fired U.S. attorneys received notification that they would be fired, several were in the midst of high-profile public corruption investigations involving Republican officials. We have learned that U.S. attorneys were rated on a removal list based in large part on whether they were loyal Bushies. However, after numerous interviews with Justice Department officials and reviewing of department documents, it is still unclear who within the administration was responsible for placing those particular U.S. attorneys on the list. The Justice Department testified before this subcommittee that the U.S. attorneys were removed for quote-unquote performance-related reasons. However, internal department evaluations, letters of commendation from department officials, and numerous awards from outside groups clearly contradict that testimony. In fact, mounting evidence suggests that reasons set forth by the department are misleading and that the U.S. attorneys were improperly dismissed. Although the President has a right to dismiss U.S. attorneys, he does not have the right to remove them in order to interfere with ongoing investigations or to retaliate against a U.S. attorney for not prosecuting cases that would benefit a particular political party. Politics should not be injected into decisions to bring the full force of the law against an individual. If even a single U.S. attorney lost his or her job either for prosecuting Republicans or for refusing to prosecute Democrats, this would represent a serious threat to the very notions of fairness on which our justice system rests. In order to restore the American people's faith in the administration of justice, we must know with absolute certainty that those who are charged with crimes are charged based on the evidence and not because of political considerations. Despite our attempts to expedite the Judiciary Committee's investigation, we have been barred from learning whether these U.S. attorneys were fired for an improper purpose. While we appreciate the Justice Department's general cooperation with our investigation, the Department has withheld materials that are clearly related to the mass firing and were requested by the committee, including unredacted documents with key information. Chairman Conyers has issued a subpoena for their production, and the deadline for their production has passed. Although the President has publicly pledged to get to the truth of the matter, the White House continues to be an obstacle in concluding this investigation. On March 9th, Chairman Conyers and I sent a letter to White House counsel Fred Fielding requesting testimony and documents from White House officials with direct knowledge of the facts and circumstances in the U.S. attorney's controversy. Despite Chairman Conyers' repeated attempts to reach an agreement on the terms under which White House testimony and documents will be shared with the committee, the White House has refused negotiations. We continue to be hopeful that the White House will cooperate with this investigation. However, after nearly 2 months of stonewalling, we still have not received any information from the White House. Such tactics do not inspire public confidence in the administration, but serve only to increase public doubt in the administration's integrity and commitment to equal justice under the law. Our investigation has also revealed that administration officials discussed firing U.S. attorneys while using Republican National Committee email accounts. As a result, this committee has also requested that the Republican National Committee produce copies of emails from White House officials concerning the issue. Instead of allowing the RNC to immediately comply with the request, the White House has slowed the production of documents by asserting a flimsy argument that they must review all of the documents for claims of executive privilege. It is my hope that this morning's testimony from James Comey, the former Deputy Attorney General, will bring us one step closer to resolving this matter. I want to thank Mr. Comey for his gracious cooperation with our subpoena and make clear that he is participating in this hearing under compulsion. I would now like to recognize my colleague, Mr. Cannon, the distinguished ranking member of the subcommittee, for his opening remarks.